All right, sir, on your bill.
Thank you, Mr. Acting Chair. House Bill 236 is on recommendation from the Louisiana Law Institute. It's an update of the law from the child custody proceedings. This was from a study done by Senator Jonathan Perry in 2018. Senator Perry is actually a judicial judge now on the First Circuit? Third Circuit. So you have a former senator, and now he's on a circuit judge. And I have here with Professor Andy Carroll to answer any questions. Thank you.
Ms. Carroll, I don't have a card on you. Would you fill out a card too?
I filled one out.
All right, good deal. Thank you. Go ahead.
I'm Andy Carroll for the Louisiana State Law Institute, and I'll just give you a brief several-sentence version of this. Louisiana has long had in the family law statutes a provision that allows for an evaluation by a licensed mental health professional. That is, the court can appoint a licensed mental health professional to do something. But what has been very confusing in Louisiana law is what that something is, whether it is a mental health evaluation of the parties for custody cases, or whether it is a custody evaluation in which the evaluator would determine and perhaps render opinions and make recommendations on how custody should be shared between the parents. That has caused a number of problems insofar as judges have in the past taken these reports and kind of considered them gospel. They've been very hard for families to look behind and sort of second guess. It's been unclear what the qualifications of the licensed mental health professional are to render what is truly a custody evaluation. So we have had a resolution on this for a number of years. We've made several changes over the years on mental health and custody evaluations. This is kind of the third or fourth iteration in that improvement of the law. And what this bill seeks to do is to divide out mental health evaluations and custody evaluations. Both of them are possible, right? But we are being more clear about which one is being done and what the standards are. So the first part largely keeps intact mental health evaluations and the rules applicable to those. The second part creates new law based on what most other states have done and what probably should have been the case all along in Louisiana for custody evaluations. It sets out the qualifications and the experience of the person needed, how the judge is to take that report, namely that it is some evidence, but there is no presumption in favor of its correctness. The judge still has to do the judge's job in awarding custody, and it sets out rules about fees and whatnot. So the goal is to divide mental health and custody evaluations and to provide clear standards applicable to both in the interest of making it more clear what a judge is permitted to do and not permitted to do.
Okay, thank you. We have a couple of questions. Representative Brown for a question.
Thank you, Mr. Vice Chair. Professor Carroll, welcome. I know Judge Holders would be surprised that I actually read this bill last night. I think the bill does exactly what we have been needing for quite a while. And as I read it, did we have a bill last year that pertained to this section?
2 years ago.
2 years ago?
Mm-hmm.
I think this is pretty clear on what we're telling the judge, and that the evidence is persuasive and permitted as guidance for the judge, but we're not having an evaluator make the determination, or not having that be the sole determination in deciding the case. And I think it was important to delineate between custody evaluation and a mental health evaluation. So I want to thank you for being back here in the I guess it was the Law Institute's work. So thank you.
Thank you.
Thank you, Representative. Representative Edmiston for a question.
Edmiston?
Yes, ma'am.
Yeah. Thank you, Mr. Acting Chair. So it's possible for an evaluator to evaluate both the mental health and the custody?
Correct.
Depending on whether they have these other requirements. So I'm just thinking back and having worked with kids in a school system for many years, I think we all thought that that was being done, that, whenever we had an evaluation for mental health, that same person just did custody and gave a recommendation to the judge. And depending on the judge, like you say, sometimes they take that as gospel, but really that's not really what they need to be doing. Is that correct?
Correct. That's not the intention. The judge has the discretion to determine custody, and that's the judge's role. The mental health professional can provide some guidance. And so what this bill intends to make clear is that the custody evaluator's report is some evidence. It's subject to cross-examination, subject to having other expert reports introduced, and subject to the judge's discretion whether to take any, reject the whole, or any version of that.
Right. And again, in the past, my dealings, more than a couple of times, one of the other parent feels that there's a bias. And so, again, if it could just be a piece of evidence, not that this is what we're going to give you, Judge, and this is what we want you to do. So I think this is good. I appreciate the legislation, Representative McMakin. Thank you.
All right, thank you, Representative Glorioso, for a question.
Thank you, Mr. Acting Chair. Thank you. My question is relating to the custody evaluation. So who appoints the mental health evaluator?
The judge does.
And so in a practical, this bill is not going to accomplish what you want, because if the judge is picking the person, they're going to give greater weight to the person they pick. Why wouldn't we just have the parties have their own experts testify unless the parties consented to the judge appointing someone?
They can. I mean, that would certainly be a possibility. First of all, the parties can still appoint their own or hire their own expert witnesses. The judge can also do so if the parties refuse to agree. And we know often the parties in family litigation are very contentious, so the likelihood that they get together and agree on a neutral custody evaluator is relatively slim. Then what happens generally in these cases is that custody evaluations are extremely expensive. And so part of the issue is that the party with more money can afford to hire numerous custody evaluators and bring that evidence to court, but the other person can't necessarily. Allowing the judge to appoint a custody evaluator and allowing the judge to apportion costs helps to, prevent the party with more money monopolizing the litigation.
I just see this as creating more abuses in the system, though. We already have a system where the judge has, in my opinion, too much power because it's not subject to review. There's no de novo review of fact. And now you're letting the judge give someone else who's not an elected person at all that authority, and then you're telling the judge to give it less weight, which they're not going to do because they're picking the person, so they're going to give it more weight than an independent expert. We generally don't let experts testify as the ultimate determination of fact, which is what this is doing again. I think there's a lot of issues creating more abuse in the system by even having custody as part of the evaluation. I'm 100% in favor of mental health and maybe addressing pros and cons without making a final determination, but to have an expert make a final determination as to what the appropriate custody determination goes to the ultimate determination of fact, which should be left up to the judge.
I don't disagree with that, but for me, the law already permits the abuses that you're describing, Representative Glorioso. Right now, we have a mental health evaluation that has shaded into a custody evaluation, and there's no law setting forth how the judge is to perceive that. So
why don't we just preclude the custody evaluation as part of the mental health evaluation and keep the mental health evaluation?
Because family court judges have said that they need custody evaluations. It's a tool in their arsenal that they need because they're hearing the family in court for 5 hours of the family's life, and it's not enough for them to evaluate everything that they need to evaluate. They need to have the opportunity to have this tool.
But it's our job to make that determination. And then mental health evaluation can address other issues that may be related, but without making an ultimate determination of fact. I mean, if they run for office, they should be able to do that job. That's the way I would look at it. Instead of giving them enormous power and then the authority to delegate that power to an unelected person when the parties could generally have their own expert, or then agree. I don't have a problem if the parties agree to have a third person do the determination because for cost reasons, whatever, but to let a judge pick someone and then assume that judge is not going to give that person greater weight than the expert that the individual party may hire is not practical in the actual courtroom circumstance. It's not going to happen.
Well, my view is that it's not a delegation of power from the judge. It's the judge using a tool of an expert. The judge doesn't have necessarily the same qualifications, even though elected to be family court judge, doesn't have the same qualifications as a mental health expert that has worked in the custody field for many years. So it allows the judge to take advantage of those resources and that expertise.
But that's what the party's job is to bring their own experts in and present their position, not the judge to select an expert of their choosing who may have biases or whatever, and now you have an expert that's going to be giving greater weight than the expert that the parties bring in. And generally in litigation, each party has the right to bring their own expert in, and then the judge can weigh the testimony of those two experts independently. But now you're creating a situation where the judge is going to pick their own expert, and in practicality, they're never going to give equal weight to an expert hired by the parties when they've chosen this other person.
I understand that you believe that will be the result. I don't think that this bill does that because the judge is already permitted to appoint one of these experts. And if anything, this bill is intended to, and does, I believe, make it clear that there is no presumption in favor of that. The judge, we're not creating for the first time the ability to appoint someone who can render an opinion on custody. That already exists in the law. What we're saying here is that there's no presumption in favor of that report, and that it's subject to cross-examination, subject to all of the typical rules of evidence.
But on appeal, how's that reviewed? Abuse of discretion, right?
It is.
So, I mean, it's in practicality, you essentially have no rights to appeal because it's a factual determination by the judge, and what the judge's determination was is purely within the judge's mind. But everyone's going to believe there's an inherent bias in the judge selecting an expert and then weighing that expert against an expert chosen by the parties.
But the remedy to that would be to change the appellate standard.
Or not to allow a expert chosen by the court to testify as the ultimate determination of fact of custody.
Correct. We chose not to go that far because we think judges need these tools. And again, if this bill does not pass, judges are still able to appoint these individuals. There's just no guidance as to how that report is to be treated.
I understand.
All right, thank you. Representative Taylor for a question, please.
Good morning. I'd like to thank the acting chair, and also I'd like to thank you, Rep. McMakin, for bringing this before us today, because I find that basically we have had circumstances where we have not addressed mental health issues. We had a devastating blow from way in the past, mental health systems, shutting down mental health facilities. This is a crucial issue. Even driving here during the day, we see people standing in the street and trying to flag you down. These people should have mental health care. So any issues that can help us to address and give me an opportunity to address something with reference to mental health issues in the community that affect us all, I think that, it's commendable to bring a bill that addresses this. And I think it should be highlighted because I think we have minimized or failed to address what a devastating blow we had to the mental health care facilities being shut down and people allowed to just go around, live under bridges, etc. In a society that's so affluent as it is today. I think that we should address these issues and it would help us to alleviate a lot of the problems that we have today. So it's not really a question, it's a comment about mental health issues in reference to the bill that you brought today.
All right. Thank you. Representative Egan for a question, please.
Thank you, Mr. Vice Chair. Not being an attorney, this is not my comfort zone. I am bringing a bill which will be heard whenever the chairman schedules it, House Bill 787, which is somewhat in the same sphere as this. The person for whom I am carrying this bill, Richard Ducote, is a family law and child custody attorney of many, many, many years. He had wished to weigh in on this bill, and since Thursday we have sought to have some communication between him and Mr. Chairman, but that failed. As it moves forward, I would certainly like to have his input and see if there could not be some conversation relative to the alignment of the two bills. I had spoken to Representative McMakin this morning about the possibility of deferring this, but since the Law Institute was already in-house, we chose to move ahead with it. However, I would request that in the interest of full exposure of everything relative to it, that we would consider deferring until 787 is heard and possibly hear them together or somehow conjoin them.
Okay, we still have some questions before we take that up. Let's go to Representative Edmiston for another bite at the apple.
Okay, thank you, Madam Chair. Ms. Carroll, I just want to be clear. I think we've explored and discussed the ability of the judge to pick a person either for mental health evaluation or custody or both. But we're not clear, or I'm not clear, and I want us to be clear for the record, the ability of the parents or to be able to do that. They can recommend, just explain that to me, how that rolls out now.
The parties can also hire their own expert custody evaluations. And again, part of the intent of this bill is to say that just because the court appoints one, that evaluation does not get any special deference. Now, I understand Representative Glorioso's, concerns that
Right.
if the judge is appointing one, maybe in the back of the judge's mind, he's trying to give deference, but from a legal perspective, all of them are admissible evidence. They are all to be considered. They're very costly. That's the reason we don't
Right.
force the parties to do it on their own. We're talking in the neighborhood of $10,000 and up for a custody evaluation. So this bill, again, allows the court to allocate those fees and costs appropriately. But yes, the parties can appoint their own custody evaluators.
Right, but if the parent or the party wants to do it, that has to be paid for by them. That never is paid for by the court. But if a judge is the one who appoints them, that's paid for, correct?
The judge has the ability to allocate costs between the parties.
Exactly. Okay. Thank you. Thank you, Mr. Acting Chair.
Representative Edmondson, Guy Holdridge again with the Law Institute. Just to tell all of the committee people how it actually works in the court, the judge first asks generally the parties if they want the court to appoint a mental health or a custody evaluator. If both parties agree and they both agree upon the same person, then the court, of course, appoints that person. Generally, it's when the parties don't agree or can't agree anything, and the court feels like they need one. In some situations, I would feel like I needed one, and I would appoint my own, and they would each have their own. Other situations, I would do like Representative Glorioso said. I would let the two parties have theirs come in and testify, and I think I can make the evaluator. I don't need an evaluator. Just to give you a little story, one time I thought I needed an evaluator, appointed an evaluator. They interviewed the husband and the wife. After interviewing the husband, the evaluator calls me, says, "Do not let the children go with this man under any circumstances. There's, something terribly wrong here. Don't let him." 2 days later, I read in the Morning Advocate that the husband had put out and hired someone to kill his wife. So I was very thankful that I had a mental health evaluator, in that situation, because it could have been a really horrible situation. They can pick out things that I went to law school and I have a degree in history, so I don't know about the mental, and I'm sure Representative Edmondson, you dealing with experts, plenty times they can pick out things that, the judge can't know.
Right.
But generally, the judge will allow the parties to do that
Right.
unless the judge feels like, I need an expert. This is a tough case. or
Yeah.
I think there's problems, and then you appoint one.
Yeah, that's
So
been
it's-
my experience
It's not
over the
every
years.
case that the
Right.
judge goes
Yeah.
in and will appoint.
But I just wanted to make sure, I'm sorry.
Yeah.
I just wanted to make sure that we're not cutting the parents out, that if there's someone that they feel like they would like to weigh in,
Sure.
that they're able to do that.
Even if the
Okay.
court appoints one, the parties
Exactly.
can still
Yeah.
appoint their own,
Yeah.
and they can all come and everybody will testify.
Yeah,
Yes.
okay, thank you very much.
All right, thank you. Rep. Laverdane for a question.
Thank you. I see where you're going, Rep, and I like the way you're going because we're going to have to tackle more mental health when it comes to family court. When you deal with custody and visitation, if you don't look at mental health, you've missed the boat because ultimately you want to make sure you put a child in a safe and loving environment. All we're doing is just giving a judge another option to assist in the evaluation because once you take a child from this environment to another, it's traumatic, and you want to make sure that child is maneuvering in the right direction academically, school-wise, socially. So all we're doing is just changing, letting them, bringing in an expert to deal with the mental health issues if need be. Ultimately, the judge is going to make the decision. The judges I deal with, they make their own decision. They're not going to let another expert. They will use that expertise report, but ultimately the judge will make the decision. Is that correct?
Correct.
And at the end of the day, we're concerned with what's in the best interest of the child, the Bergeron factors, where the child's safe environment, provide food, clothing, nourishing, religious activities. Okay.
And Representative, I
Please
think
do.
there's a key that is in the custody evaluations that y'all did. They came up in subsection I with specific rules about no ex parte communication with the litigant. So the litigant can't call up the custody evaluator. The attorneys can't call up the custody evaluator. We didn't have these rules in place, and a lot of people from family court says we need these rules in place, that if the court appoints an evaluator, he's to be an independent evaluator, not an evaluator that everybody can call up and then the other party comes in and says, so-and-so was calling, or I saw so-and-so at lunch with the plaintiff's attorney or the defendant's attorney. So there are in subsection I more rules regulating the interplay between the attorneys, the litigants, and the custody evaluator that the court's going to appoint. So I think it is a definite improvement by adding these rules that we didn't have before.
And once the judge and the parties determine the mental health provider, then that mental health provider will give a report to each parties, and then they will decide what's the next step. And the judge uses it as a guide. If a judge decides not to use it, the judge can do that. The judge may...
It says all written communications or correspondence to the child custody evaluator along with the attachments shall be provided contemporaneously to all parties to the litigation or their attorneys of record. So,
And at the end of the day, the judge will decide
Right.
what he or she feels. Okay, thank you.
May I add that because I think this is an important change, the current law says that the mental health report shall be provided to the court. We changed that to say it's provided to the parties, and it will only come to the court if a party introduces.
And like the judge said, we don't want folks calling the mental health, what's going on, what's happened, because you want it fair and impartial, and you want it free from bias. Thank you.
yeah, but that's the court appointed. Of course, as Representative Edmondson said, the parties can go out and hire their own and talk to them all day and night and give them all the information, of course, that they would like to give, because that's their expert that's coming in to testify.
Okay, we're good.
All right, Representative Glorioso for another bite at the apple.
Just real quick, if the court appoints a custody evaluator and they produce a report, do the parties have the ability to take that person's deposition before trial?
I think so.
There's no prohibition on
I don't know if
that?
there's a rule, but I would say yes.
Okay.
I mean, he's an expert, for the court, but he's an expert, and if he's going to give I think anyone that is going to testify at trial you surely should be able to take their depositions beforehand.
And you don't think that's something we need to specify in the bill to make it clear to other judges that the parties would have the right to take that person's deposition?
What we do say is that they're subject to the rules that apply to all other experts, which would include the ability to take depositions, and they're subject to cross-examination.
Well,
To
obviously
make exactly that
cross-examination,
clear.
yeah, but that's different than being able to take their deposition outside of the courtroom so they can prepare for a testimony.
It does say the typical expert witness rules are applicable to these individuals.
Okay, great, thank you.
All right, thank you, Rep. Edmiston. Now we're peeling an orange.
Thank you, Mr. Acting Chair. I appreciate your patience with me. Just real quickly, I feel like this is a good piece of legislation for one reason. Maybe we haven't gone far enough, but I feel like we are opening up the ability of parents to have more of a say on, what goes on with their children. I think far too long it's been just the court that they've not been able to, weigh in like they need to. I think this is an improvement. And have we moved favorably?
Not as of now.
Can I?
Yes, ma'am.
Yes, sir. I'll move favorably at the.
Thank you very much.
Yes.
You brought up a question from Representative Johnson.
Yeah, I'm a little concerned. Will the real Dixon McMackins be handling this on the floor?
Absolutely.
Then I'm sold on it completely. Appreciate you bringing the bill.
Hold on one second. We're a little early on that. I'll get to your objection. Right now, Bridget Neal would like to come in for information only. President would like to speak.
Hello. Thank you for letting me talk. And I know we've kind of went through this, but I'm going to take the academic approach, and then I'm going to go to what actually happens to the parents, because I'm a parent who's been in the family court system for 7 years, and I have 132 filings or other interactions with the court.
I'm sorry. I'm a little late. Would you introduce yourself, please?
Bridget Neal, the Institute for Child Custody Advocacy.
Thank you. Sorry
and a
about that.
parent to Dashiell and Annabelle. So, as an academic exercise, the reason that we have child custody evaluations is because the judge doesn't have time. This person's supposed to go out and collect data. From that data, create information. From that information, they're supposed to turn it into some kind of knowledge in order to give wisdom to the judge, who is basically a conveyor belt of parents because their dockets are full. They don't have time to listen to the dynamics of everything. And the reason that child custody evaluators are so focused on is because they are the default evidence gathering mechanism and due process procedures for every parent that goes into that courtroom. And they're not using any of that information in the evaluation. I think that this bill, which is based on the resolution that my institute pushed forward, our institute pushed forward, is a great start, but it doesn't address the strict scrutiny evidentiary standards, and it doesn't address due process procedures. Because, again, all of that's happening within the custody report, and the judge takes that report and basically treats it like the Bible, and even when you present contrary evidence, you almost never get back whatever it is that you've lost. Okay, so my ex-husband decided that, swear to God, this is the story. He got remarried and said that I could become the fun aunt and his new wife would be the mom. And I said, because I'm from Ponchatoula, you take my parental rights over my cold, dead body. And he said, I can do that. Here I am, 7 years later, 132 filings and interactions, and I don't have any parental rights. I have never had an addiction. They never claimed that I had an addiction. There was no claims of abuse. The only argument was I yell. But let me give you, not berate, yell. Put your shoes on. I said, put your shoes on. Put your shoes on or you're not getting TV tonight. That was the example of yelling. The way that it kind of worked was he started off with this lie called I had borderline personality disorder, which was not based on any medical evidence. And then he went around telling everyone. And everyone he told, I would go and argue with them about it. It's not true. Talk to my Dr. Barbie is an expert who's my doctor for 15 years. Go talk to Dr. Barbie. This isn't true. And at some point, I decided that I had lost my job and I wasn't a good parent. Being a good parent to my kids, I wasn't enjoying them. And I decided that my constitutional and fundamental right to parent wasn't contingent upon all these people liking me. And why I'm saying that is because I might have told my custody evaluator that she lacked the metacognitive skills to deal with the complexity of family dynamics, which was a bad move on my part. But again, I didn't think it was contingent upon liking me. But once you're in the family court system, it functions like the Stanford prison experiment, which happened in the 70s. Stanford University wanted to see how environmental factors impacted people's actions. So they got a whole bunch of students, they did baseline psychoanalysis testing on them, and they made part of them guards and part of them prisoners. It was supposed to go for 2 weeks. It only lasts 7 days. It's probably the most infamous psychological experiment in history because the guards became so abusive towards the prisoners in an act of compliance they had to stop the experiment. So in this analogy, the prison guards, co-parenting therapists, child custody evaluator, reconciliation therapist, there's all these extraneous people who get involved, and truth doesn't matter. Fact patterns don't matter. It's about compliance, and you start jumping through these hoops, which are not healthy. And I call it a prison because a lot of these cases, one, they don't even get asked to be an exception, which means that you don't have enough evidence because there's no evidentiary standards in family court, which goes back to what you're trying to address. You get into this cycle of all these people involved, and one parent loses. So I guess what I'm trying to say is two things. One is, no matter what we put in these bills, unless it's something more aggressive, the judges are almost always going to default to the custody evaluation and treat whatever's in it, even though it has no evidentiary standards or due process procedures, as fact. And you cannot beat it back. No matter how many times you file against them, you cannot beat it back. And even when proven, you can't get your custody rights back. So I'm hoping that we take at least the top half of this bill, if not the whole thing, but also add in the evidentiary standards and the due process procedures. I could tell you, through the Institute's work, we collect stories because we're interested in, but I did it the way that people with money do it, which is through the court system. But there's a lot of other fit parents who are losing custody because they run out of money. There's parents who just can't fight an abusive ex-spouse. 75% of the people who come through family court have at least one domestic abuse claim. That means at least one of those people are an abuser. And to talk about the weight given to these experts, in my case, I actually had my ex-husband's father and my ex-husband's brother testify against him. They had to leave Louisiana and their grandkids because of the way he abused them. And it still wasn't enough to counteract the experts. So I'm in agreement with Professor Carroll that we have to get the judges to stop putting so much weight into these experts, but we also have to get the experts to create a methodology. So my background is I've worked at the Smithsonian in the Office of Sponsored Projects, which means we do research grants. I've worked at NASA. Now I'm at George Washington University, also in the I have always worked with elite researchers, which is why I knew based on the report there was no scientific methodology and she couldn't defend any of her findings, hence my comment. But we should require that. We require methodologies in everything else that we do. So why not force them to say, this is who we talked to, this is why was it's just a defense of how they got to their conclusions. And maybe the answer is that they don't get to make recommendations. Because remember, they're supposed to be giving the judge facts, not necessarily recommendations. They're supposed to be the fact finders, not the decision makers. Back to my Stanford prison analogy. one of the things about these family court judges is they have different backgrounds and different things, but family court is where you do your time on the ladder of becoming a judge. It's not a place that even judges really want to be in most of the time. It's the place that they start in order to move up and get elected into other positions. And because of the way the practices are in the courtroom, particularly the best interest of the child standard, which is just an umbrella in order to throw out all constitutional protections for parents, these judges are learning the wrong practices and learning the wrong way to conduct trials as they move up. So I'm hoping that this bill will get consideration or be combined with HB 787. And I did speak to Richard this morning. And so the reason that he doesn't like the current list bill is he doesn't like custody evaluations. He believes that there's no validity in custody evaluations and that the list bill legitimizes the whole point of custody evaluations. And he's actually right that they're not full of facts because, like I said, there's no way, they're not accurate.
Thank you.
I think that's all I want to say.
Thank you.
If you have any questions, I'll be happy to answer
No
them.
questions.
Of
I do
course.
have two cards in opposition, Ms. Susan Rayburn and Catherine Diamond.
Okay. Thank you, guys.
Okay, please state your name and
Hi, Susan Rayborn is my name. I am an attorney. I have done some family cases. I'm a federal attorney now, but I am also 5 hours shy of being certified as a biblical counselor with my church, Woodlawn Baptist Church, through Association of Christian Biblical Counselors, ACBC. The first thing that I would like to say that might be kind of a shock to you all, we don't need any psychologists running the family court. They need to be out. It is a racket. It is a few that have a monopoly that make tons and tons of money off of litigants. It is it is, as a Christian, it's a religion. And I am not of that religion. And to force a Christian to undergo any kind of mental health evaluation, I would tell all of my clients, it's against your First Amendment right to practice your religion. It is against my practice of religion. The whole idea that you have to have psychologists, not a psychiatrist, we're talking most of these are psychologists, to tell people what to do, how to run their life, how to run their kids, how to do this, how to do that. And by the way, they're going to tell the judge, it's everywhere. They have these psychologists now in hospitals trying to tell surgeons how to speak to a patient before they go into surgery. Like as if they know. So you can't tell somebody, we need to get you into surgery right now or you're going to die in 5 minutes. Oh, that's not, you need to kind of be kind to them and do all this kind of stuff. They have them running corporations where they're deciding who runs a corporation or not based on these psychology studies. We have them in the courts trying to dictate to judges, and they're used out of control. They are used by one litigant or the other against litigants. In my opinion, the ones that I worked with, and specifically a couple that I got kicked off of a case because they're just outright trying to practice medicine. They're not allowed, a psychologist isn't allowed to practice medicine without a medical license. And
would you like to take a question, Ms. Rayburn?
Yeah.
Representative Glorioso for a question.
Thank you. One of the concerns I would have with this process, and we've seen this in other states, is let's say you have a 5-year-old child and that child decides for whatever reason they believe they're transgender, and one of the parents says, well, you're too young to make that decision, we're not going to do that or whatever, and the other parent wants to go along with this, and then you have this psychologists come in and say, well, that's the parent that doesn't want to foster this belief in a 5-year-old now is unfit to be a parent because they're not following this political agenda that these people follow, or whatever. Now that person's going to give a report to the judge and say the parent that doesn't want to allow a 5-year-old to become transgender is now unfit. Is that what we're dealing with?
Exactly. The same thing they're trying to do in the medical field. Well, you need to leave your ideas of transgender or, operations at home, because when you come to the hospital, you need to be able to do whatever somebody wants, even though it's against your religious belief, to operate on somebody and do some kind of transgender surgery. It's prevalent in all walks of life. But what I have experienced, that is where this is all going, and that is what they do. Because one parent gets the psychologist to say this. What's the psychologist's belief? What's their belief? What's the judge's belief? Where's the jury? That's the whole thing about family. Where's the jury? If you've got something and people can't agree about a custody, where's the jury? These evaluations are thousands and thousands. You heard her, 10 grand. Who has $5,000? Why aren't they putting it in the Louisiana START account for a college education? All this psychology, we got to take the child to the psychologist. Let's put him on ADD drugs. You know what? My dad was a pediatrician. He called it LHB disease, lack of hand on butt. They are drugging up. They put drugging up the children so that they can, supposedly be a little bit more sedate. We have to get the psychologist out of the family court. Number two, what you were saying, I don't understand the workings of how, if there's a law, why we can't overturn a law. But what Rep. Glorioso was saying is so true. I go back to, we need a big overhaul of the whole family court system. What's going on there is out of control. And I also think we need members of the public on the Law Institute, because some of the, all you have is some attorneys that are in the Law Institute. Where's members of the public?
From Representative Brown? Representative Brown?
Thank you, Ms. Vice Chair. I don't know if it's so much a question that I don't disagree with some of the points that Representative Glorioso has made, but in a practical sense, in my district, nobody's spending $10,000 on a child custody evaluation. Nobody can afford it. They can barely afford an attorney. So in many cases, the judge appointing a custody evaluator is the only hope in this case. And I will tell you more times than I would like to admit. Let's say I'm in a family law case, a custody trial, or going through the process, and I have the judge on my side. I've been very persuasive. But when my client has to go through a custody evaluation, that custody evaluation many times can see through that client better than the judge. And a lot of times they'll come back with a report about my client, and I'll say, yep, they nailed my client. They got it right. The judge would have never seen it. But they actually see what's going on. But I can't tell the court that. I have a job to represent my client. But that evaluator sees a different perspective than the judge. And I'm not going to say that I don't have concerns that you have about sometimes they have relationships there, or it's one-sided. But most of these people that I've dealt with are professionals, and they get it pretty on the head when they do a custody evaluation. And those judges don't completely, the ones that I have been around, don't completely use that custody evaluation. So that's what the evaluator said, that's what I'm going to rule. But I just think it's a valuable piece that we can't just throw out the validity of based on there are some imperfect situations. I will grant you that. But I just think these evaluators provide a good tool for the judge, because the judge can't sit there and know everything, and he's only hearing what each side presents. And I'm going to present the best side of my client, not the negatives.
What about a pastor? My pastor knows more about anxiety, because the Word of God says, be anxious for nothing, but in everything through prayer and supplication with thanksgiving, let your requests be made known to God. The book of Proverbs is all about making good friends and how to reject godless friends. The Word of God is about marriages. So you're eliminating my right. If I were to be in this situation, you're eliminating my right to have my pastor's counsel and to practice my religion and my First Amendment rights, because now you're telling me that I've got to go to hear some
I don't think we're telling you can't go to your pastor.
When they're telling...
We're not telling you can't go to your pastor.
I think, give me 1 second. I think Representative Taylor, do you have a motion?
Yes, I would like to invoke the 3-minute rule.
All right, any objections to the 3-minute rule being adopted? Not seeing any objections, 3-minute rule will be adopted. Representative Brown, you're back on the mic.
I'll wrap up. I don't think this bill precludes you from going to your pastor.
It says a mental health professional with all the little L.
That's to be selected by the judge. But you can still have your pastor testify. You can still go to your pastor for counseling.
Why would I, as a Christian, ever want to undergo or spend any time in the presence of some mental evaluator who I disagree with their worldview to begin with? I disagree that anything that they come up with is subjective. It's not scientific, as the previous woman said. It's not scientific fact. It's based on theory. And when you're dealing with children, some people have ways that they raise their children that are different than other people. And it may be different than a person with all the letters behind their name. And
your pastor can testify to that.
Why would you have as a Christian?
I'm a Christian. I don't have a problem with it.
But you're going to have a law that a judge can tell me and my children, who I'm supposed to raise, you're going to have a judge be able to tell me that I have to go see a psycho person, and my child has to, and to put that on me, and I'll be standing there saying, this is against my First Amendment rights. This is against my practice of religion. I don't believe in this. I don't believe in a lot of the worldview of psychological theories. It is an absolute law that would go against many people that consider themselves Christians to be forced to do this. Should a judge decide that's what we want you to do, and you have to do it. And I would counsel anybody and say, don't do it. Don't do it. Don't ever do something like that.
I think that same person could say, then I shouldn't be subjecting myself to the court.
I have told them that, Rep. I have told everyone
So we're going off on a whole different, we're going outside of if we're going to say we're not going to be subject to a mental health evaluator or the court, then that's on a whole nother discussion, I believe.
But the issue is, where in the United States of America do you see in any of in the Constitution that to go to court you have to be possibly subjected to psychologists? No, you shouldn't have to be.
I think it's all over in our...
That's why we have a jury.
I think it's all over in our court laws that you can be subject to a mental health evaluation.
And that has been 3 minutes. We're going to move on to the next witness. Thank you, Representative. Didn't mean to cut you off. Yes, ma'am. Will you please introduce yourself? You have 3 minutes.
First of all, I would like to say I hope I'm not the only witness that's only going to be limited to 3 minutes when everyone else had the opportunity to express themselves. I don't think it's fair. Because I have some very important points to make, and everyone else had the opportunity to explain theirs, and I'm going to be limited, and I feel like I'm the only one, and I don't appreciate that.
I'm sorry you feel that way, but we had a representative that asked for the 3 minutes.
I'll try to talk really fast. Okay, so I'm going to be the only person that can't. Okay.
No, ma'am, it goes from here on to the rest of the day. Thank you.
First of all, I would like to bring attention to an article that was in ProPublica, published on March 18th, 2024. It's entitled, "An Expert Who Has Testified in
Ma'am,
Foster..."
please introduce yourself for the record.
Catherine Diamond. on March 18th, 2024, there's an article by ProPublica called "An Expert Who Has Testified in Foster Care Cases Across Colorado Admits Her Reports Are Unscientific." And that's a really great reference in regard to this case. Also, I wholeheartedly believe that family courts, which is completely an unregulated industry, is being used to bleed families, both sides of their assets, to go to court professionals such as attorneys, custody evaluators, court reporters, just a whole industry of people. It's a whole racket. So I think that basically what's going on is this amounts to a witch hunt where a highly funded individual can go to certain attorneys with certain types of inappropriate relationships and get the kind of outcome they want. I think that the basis to all of this is family court is being misused as an opportunity to make a lot of money. I think the only time that there should be a change in custody is whenever it is there's some sort of allegation that is given to an organization that is equipped to investigate, such as DCSF or criminal court. I do not believe that family court is equipped to investigate anything. Really, anything. And also, I don't think that you should risk losing your children unless there's something, significantly detrimental happening to the children, which should be addressed by DCSF or by the criminal court. There's problems with the appeals process. If you have a malicious judge, the judge is considered a credible fact finder. If they're willing to lie on the record about the evidence, then you have no ability to have the real truth come to light. If you have a situation like this and you want to file a complaint against your judge, it takes 3 to 5 years before the investigation is complete. And by that time, you've likely exhausted your appeals and any other recourse you have. Let's see. I think this is a very interesting quote from the investigation by the Judiciary Commission regarding family court judge Charlotte Day. The very first sentence of the report says this case arises from Judge Charlotte Day's repeated abuse of her contempt power, thereby
depriving... Ma'am, that's been your 3 minutes. I actually let you go over a little bit.
Can I finish the quote, please? It's one sentence. It's the first sentence of the Judiciary Complaint investigation by the Judiciary Commission, I'm sorry. May I please finish it?
I said yes, ma'am.
Oh, I'm sorry, I didn't hear you. This case arises from Judge Charlotte Day's repeated abuse of her contempt power, thereby depriving individuals, which would be parents, of their liberty without due process of law, and her repeated failure to recognize the impropriety of her actions in this matter. She is on the bench now.
Thank you for coming to the Capitol. That's your time. Not seeing any questions. We had a motion by Rep. Edmiston to move forward, favorable with the bill. The Representative Glorioso has withdrawn his objection, so not seeing any objection, we will would you like to come to the table so I can say it? We will report HB 236 favorably. Thank you, Representative.